you, my lord. My lord, I have only 2 submissions to make, my lord. On the objections raised by the defense in the inclusion, my lord, of the new evidence. My lord, as my learned friends have submitted the reasons that needs to be considered on this application, and one of the reasons, my lord, is the delay, reason for the delay in leading or in introducing the evidence that a party intends to introduce at this stage. The reason, my lord, which I found on the heads of the argument submitted by the state in respect of accused number 2 is that the state only had an opportunity to go through its own evidence, which is 5,467 photos. And it's only then they realized that the state wanted to introduce this evidence when I read through the heads of the arguments of the state, my lord. My lord, my submission is that so it means the state, at the time when the state was supposed to furnish the defense, in particular accused number 2, with further, full, and better particulars in order to enable accused number 2 to prepare his defense, the state did not comply with those provisions, because the state is saying, my lord, on its own heads of arguments, they only had the opportunity to go through the evidence during the adjournment when Advocate Mnisi was preparing for his cross-examination. That on its own, my lord, it shows that the state was reckless in reading and analyzing and preparing the evidence that the state wanted to introduce, that the state wanted to use against accused number 2. It shows that the state from the outset never intended to use the information or the evidence that they now intend to introduce, because it was lying in their hands, but they elected not to introduce such evidence, my lord. And therefore, that on its own has violated the rights of the accused to a fair trial, in that he had not been afforded with an opportunity to prepare his defense case from the outset of the trial. Therefore, the inclusion of this evidence, my lord, will affect the right to a fair trial of accused number 2 on the basis of the reason that has been submitted by the state. Then on the part of accused number 3, my lord, also on the reasons for the delay, the state on its own heads of argument, my lord, indicated that it is the investigating officer who picked and chose the photos that were supposed to be included in Exhibit S, which was presented before this court. Therefore, it means, my lord, at the time when the state was preparing the evidence, the state was in receipt of this evidence, and therefore it was the issue of the investigating officer to pick and choose which evidence to be presented and which evidence not to be presented against accused number 3 in respect of the pictures that the state had at the time when they were preparing Exhibit S, my lord. Also, it means, my lord, the state was negligent on their part. Also, my lord, it goes further to say also the state has failed to give accused number 3 the evidence or to furnish, not to give, my lord, to furnish accused number 3 with further, full and better particulars in order to enable accused number 3 to prepare his defense case, my lord. Now, the introduction of this new evidence at this stage, my lord, will be prejudicial to both accused because the reason submitted by the state for failure to include such information at the beginning, it shows that they were reckless. The state was reckless, my lord, or did not pay particular attention to the evidence that they intended to use. My lord, I may submit that the inclusion of such evidence will be prejudicial to the accused, my lord. Those are my submissions only.
Thank you. Any response, sir?
As a court, please, my lord. Well, firstly, as far as the arguments of Advocate Nisi and Mr. Ramasipele is concerned, there appears to be a serious misconception as to the reason why the state seeks to lead to the evidence, and we are saying this, my lord, with the greatest of respect. If one looks at the argument of Advocate Nisi, he mentions, for instance, that there's no valid reason as to why the evidence wasn't led through Brigadier Gininda. He also mentioned that there's no explanation as to how we missed the evidence. And if one looks at the argument of Mr. Ramasipele that the photos are not new evidence, that we perhaps are reviewing our strategy, that our strategy was to lead certain evidence, that there's no averment that there was an oversight or omission on the part of the state, that the state wants to have a second bite at the cherry, and that the evidence is repetitive or irrelevant. If one looks at those submissions, my lord, we submit that there's this fundamental misconception of the reason why the state seeks to leave the evidence at this point, my lord. And we've played open cards. We've come before the court and said this evidence, when we led Brigadier Gininda, that the photos had not as yet been identified. We mentioned, my lord, in our heads of argument on Friday that it was during the long adjournment, and this we set out in our heads of argument that we presented on Friday, that it was, and this paragraph 2.3, that the reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Nisi to prepare his cross-examination that we were able to trawl through the 5,467 files. And we've come to the court, we've played open cards and said these photos were discovered, and I use discovered in the sense that we were able to identify those photos after the evidence of Brigadier Gininda in chief was led. So in other words, this evidence was not available at the time when, and I'm using the word available in the sense that the photos had not as yet been identified at the time when Brigadier Gininda gave his evidence in chief. Well, Advocate Mshololo then submitted that this is new evidence and mentioned that the state was reckless and that we did not finish the requested further particulars. And as far as accused number 3 is concerned, she submitted that the state failed to give accused 3 or to furnish him with better particulars. The fact of the matter, my lord, is that the photos, as we've indicated, were contained in the disc that was given to all the defense counsel some time ago, and in our submission, my lord, this was sometimes in 2023. We don't want to commit to the year in case we are accused of not putting correct facts before the court. But this is a long while ago, my lord, that the evidence was furnished to the to the defense. I can put it as high as saying that even before the resumption of the trial, that this evidence was furnished to the to the defense. So they can, my lord, we submit with the greatest respect that they it cannot be argued that we failed to furnish further particulars when we furnish this information in a disc before the trial commenced. And my lord, as the trial unfolded, certain propositions were put to the witnesses, and in this regard, we just want to refer to a proposition that was put to Mr. Tumela Madlala. This was on the 8th of August 2023 on page 13, line 14, by Mr. Ramosepeli. He put the following proposition: now accused number 2 instructs me that he has never had this beard here. In fact, it does not grow on him, and he has never had an O-shaped beard like you say the second suspect had. And furthermore, that he has always kept the goatee, the one that you see here in court, from as long as he can remember. And my lord, these are some of the aspects that only came during the cross-examination of the witnesses. And my lord, the photos that the state seeks to hand up address these issues that only came to light during the cross-examination of the witnesses. The reason, my lord, why we quoted the passages that appear in our heads was simply to show relevance as to why we want to present the evidence. We therefore submit, my lord, that the state should be given the opportunity to lead this evidence. We have advanced the reasons. We've played open cards with the court, and we are of the view, my lord, that there can be no question of prejudice, my lord, because these are simple photos of the accused. How can a person be prejudiced by the way that he looks? Mr. Ramosepeli mentioned the fact that the photos are irrelevant in the sense that there's no date as to when these photos were taken, but one thing is certain, my lord, is that these photos were taken before the arrest of the accused, and therefore, my lord, this will be relevant as far as the period within which the offense was committed is concerned, my lord. We therefore reiterate that the state should be allowed to lead evidence on these photos, my lord. Thank you.
What's the time there?
It's 11:15, my lord.
Okay, can you come back at the half past?